Hello, and welcome to the lecture series for Ethics in the Legal Environment. This is lecture 3.3, and I'm Roun McNeal, the lecturer. In this episode, we will analogize the simplest lesson that children learn when they transgress the rules set out by their parents, that actions have consequences. In the last lecture, we learned two new duties of lawyers: diligence and communication. Diligence is essentially doing the work promptly, and communication is an extension of one of the foundational principles. The client is the principal and owns the representation. It is necessary to communicate with the client regularly so that the client can direct the goals and objectives of the representation. We will continue to talk about the ethical duties that lawyers owe to their clients, but in this lecture, we will discuss for the first time the consequences of failing in those duties. There might be lots of practical consequences that naturally flow from professional misconduct, but in this lecture, we'll be talking about two particular types of imposed consequences: ethical complaints before the Bar Association and civil lawsuits for a cause of action of legal malpractice. Failing in the duties of competency, diligence, or communication, or other duties can lead to ethical complaints or legal malpractice lawsuits. Legal malpractice lawsuits belong to a class of civil lawsuits called torts. A tort is any non contractual civil wrong, which just means that it covers all the types of lawsuits where a plaintiff sues a defendant for money based on an injury caused by the defendant. So, if a lawyer's failure to act diligently and competently causes his client to lose a slam dunk case, or lose some legal right or benefit, or suffer some other kind of loss of money or property, the client might file a legal malpractice lawsuit. To understand legal malpractice lawsuits, let's remind ourselves of the elements of all types of malpractice lawsuits. Those elements are duty, breach of duty, causation, and harm. It's actually relatively simple to remember these elements because they are the things that are logically necessary to determine that one person owes another person compensation for some kind of injury. The first element is duty, meaning that one person has a duty to act in favor of another person. In legal malpractice suits, this is easy to understand because we have already talked about the duties of competence, diligence, and communication that lawyers owe to clients. Breach of duty is similarly logical. If the lawyer fails to live up to his duty of competence, for example, he has breached that duty. The last two elements, cause and harm, simply mean that the lawyer's breach of duty actually caused some kind of harm. Let's put that into a very simple hypothetical. Let's say Larry Lawyer is hired by Kathy Client to draft a land deed because Kathy is selling her house. Kathy plans on completing the transaction 1 week later at Larry's office. Larry takes Kathy's money, but forgets that he is planning on being on vacation that day. He remembers later, but is so embarrassed that he can't bring himself to call Kathy and reschedule. Kathy and her buyer show up at the office. No one is there, and the buyer angrily leaves and withdraws his offer to buy the house. In this hypothetical, Larry owed duties of competence, diligence, and communication to Kathy, all of which he breached by not doing the work and not communicating with her about the scheduling conflict. This breach caused Kathy some financial harm. She missed out on the money she would have made from selling the house. Kathy might file a legal malpractice lawsuit against Larry. This simple explanation of torts might have been review for some of you, but let me caution that there are two wrinkles that are specific to legal malpractice suits when compared to other types of tort lawsuits. First, in the context of legal malpractice suits, the type of duty that the lawyer owes the client is called a fiduciary duty. This is an important term to remember. A fiduciary duty means a duty to act in the best interests of another person. When a lawyer takes on a legal matter for a client, remember that the client owns the matter, so a lawyer is promising to handle that matter for the client. The lawyer is promising to act in the client's best interests. This is what we mean by a fiduciary duty. The second wrinkle involved, particularly in legal malpractice lawsuits, is proximate cause. Proximate cause is a somewhat complicated legal concept, but the easiest way to think about it is foreseeability. In other words, if a lawyer makes a mistake that indeed violates a duty and even is possibly the cause of the client's harm, that lawyer still might not be liable in legal malpractice if it was not foreseeable that the mistake would cause the injury. Let's use a different hypothetical to illustrate proximate cause or foreseeability. Imagine if Larry actually prepares the land deed for Kathy and leaves it with his paralegal so that Kathy and her buyer can close the deal while Larry is on vacation. But before the day to close the deal, a thief opens an unlocked door in Larry's office and steals some of Larry's files, including the file containing the deed he prepared for Kathy. And let's say the thief knows Kathy's buyer, and has a house he can sell to the buyer, undercutting Kathy. The day of the sale is supposed to happen. The buyer calls Kathy and says, "I'm not going to buy your house. I'm buying Stan's house instead. He told me that he found Larry's office unlocked, went inside, found the deed where you were trying to sell the house, and after Stan stole the deed, he decided to sell me his house for less money." Now, putting aside the fact that Stan is pretty foolish for admitting his crimes, let's ask if Larry is liable or responsible for Kathy's deal falling through. Now, let's assume that leaving your office unlocked is a breach of your duty of competence. A competent lawyer knows to secure his client's things. And that breach definitely started a chain of events that blew up Kathy's deal and caused her some harm. But was that breach the proximate cause of the deal blowing up? Was it foreseeable that leaving the door unlocked would lead to Kathy's deal falling through? Probably not. So because the breach of duty, leaving the door unlocked, was not the proximate cause of the injury, Kathy probably does not have a winning legal malpractice lawsuit against Larry. Here's an important place to remember that the attorney has ultimate responsibility for the work of his office. Consequently, in most jurisdictions, there is no concept of paralegal malpractice. Lawyers, not paralegals, are the professionals who enter into a contractual representation with the client. So lawyers, not paralegals, are the ones who owe a fiduciary duty to the client. Let's look at the Illinois case In Re Estate of Devine as an example. In that case, an elderly man, Richard Devine, employed the services of attorney Samuel Poznanovich for various legal needs. Devine relied heavily upon Poznanovich's paralegal, Patricia Giancola, who, in addition to assisting on Devine's legal work, also became friends with Devine and visited him at his apartment regularly, bringing him groceries and other things because Devine was mostly incapable of leaving his apartment alone. Poznanovich, the lawyer, prepared a will for the old man that included legacies of $3,000 for Poznanovich and Giancola. Poznanovich rented an apartment to Devine and eventually petitioned the court to find Devine incompetent. Poznanovich established himself as Devine's legal guardian. Then, at some point, Richard Devine made Patricia Giancola the joint holder of his checking account, so that when Devine passed away, Giancola, the paralegal, became the sole owner of $165,000 in the accounts that Devine had shared with her. Devine's family argued that because Giancola worked for Poznanovich, Devine's lawyer, that Giancola was a fiduciary to Richard Devine, that she obtained the money in his checking account through undue influence and fraud, and that he did not have the capacity to understand what he was doing. Now, interestingly, Devine's family did not sue the lawyer, Poznanovich, but only the paralegal, Giancola. The Illinois Supreme Court declined to find that Giancola owed a fiduciary duty to Devine and his estate, saying, "It is clear that Poznanovich, as a licensed attorney and as an employer, could be held liable for Giancola's actions. Nonetheless, holding Giancola liable as if she were an attorney is not consistent with general respondeat superior law or with the decisions discussed above treating paralegals as subordinate employees or attorneys. The theme running through all these cases is that paralegals do not independently practice law, but simply serve as assistants to lawyers. They are not equal or autonomous partners. Thus, while supervisors properly are held liable for paralegals' actions, the subordinate paralegals should not be liable for the actions of these superiors. Just because paralegals cannot be held liable for malpractice does not mean that they cannot make mistakes. Rather, what this means is that lawyers are responsible for paralegals' mistakes. We call this responsibility vicarious liability. You've probably heard people say that they are living their lives vicariously through someone else. That's the same concept as vicarious liability. The responsibilities of one person's mistakes are held accountable to some other person, usually someone with supervisory authority. A Latin phrase that also refers to this concept is respondeat superior. These are both terms that you should remember. That Latin translation for respondeat superior is literally the supervisor must answer. So vicarious liability and respondeat superior both stand for the principle that a supervisor has to answer for the actions of the person that she is supervising. Tegman versus Accident and Medical Investigations is another case that helps illustrate these principles. It involves Richard McClellan, who presented himself to Maria Tegman as a licensed attorney, even though he was not. McClellan's business model was to sign up clients and obtain insurance settlements. McClellan employed two licensed attorneys who both knew that McClellan was not a lawyer and knew that McClellan was mishandling settlement funds. In December of 1991, McClellan settled Tegman's claims without Tegman's consent. He forged Tegman's signature, and he put her settlement money into a personal account. This case examines some intricacies surrounding joint and several liability, but for our purposes, let's just answer this question. Were those licensed attorneys with whom Richard McClellan associated, were they liable for damages related to his unauthorized practice of law? The answer is yes. Those licensed attorneys were negligent in working with McClellan since they knew that he was practicing without a license and mishandling client funds. Let's turn from legal malpractice lawsuits to professional responsibility opinions from the Bar Association. Each state bar association has a professional responsibility committee. Professional responsibility and ethics are largely interchangeable terms in the legal world. So, professional responsibility committees just mean the folks who issue ethics opinions. These opinions differ from lawsuits because they may be advisory to a lawyer who asks for guidance when, for example, tensions exist between one of an attorney's duties and some other professional responsibility. But ethics opinions may also come after a complaint and investigation from the bar. So let's finish this lecture by finally distinguishing between these two consequences: ethics complaints and civil lawsuits. Think back to earlier in the lecture when we talked about the four elements of a malpractice claim: duty, breach of duty, causation, and harm. Those last two elements are the key difference between an ethical complaint and a lawsuit. For an ethical complaint, the person complaining does not need to have been harmed at all, so logically, causation is not an element. In order for the Bar Association to take disciplinary action against a lawyer, all that needs to be shown is that the lawyer had a duty to do a thing and failed to do that thing. So let's imagine that an attorney takes a case and takes a retainer fee from the client. Then 4 months go by without the attorney doing any work or communicating in any way with the client. The client comes into the lawyer's office, demands his money back, which the lawyer gives, and the client walks across the street to another lawyer's office who takes his money, files a lawsuit, and achieves the best result possible for the client. And the client was inconvenienced, but the client may not have been truly harmed. Nevertheless, the first lawyer may still be in jeopardy of an ethics complaint for violating the duties of communication and diligence. He waited 4 months to do anything and failed to talk to the client at all. It's important for you to remember that a legal malpractice lawsuit, a client needs to prove all 4 elements: duty, breach, causation, and harm. But in an ethics complaint, which could result in a fine, a suspension of the law license, or even disbarment, all that needs to be proven is that the lawyer violated his duty, even if the violation was essentially harmless. Now, this concludes the lectures for this unit on the duties of competence, diligence, and communication. The next unit is what I call Gandalf's rule, the lawyer's duty of confidentiality, or as Gandalf would say, keep it secret, keep it safe. Until next time.